Good afternoon. This is Raymond DeLeon with Smoothoperationoflaw. You can find me on Facebook at Smoothoperationoflaw. You could put it into Google and find the Facebook for Smoothoperationoflaw. If you want to get in contact with me, you can hit me up through Facebook. I'll accept you as a friend. And then you can also hit me up through Messenger. Today we're going to talk about the difference between secure party and secure party creditor and what assets should be the collateral. Some of the topics that are going to be discussed today are going to be very brief. I am not going to unpack this whole concept into a 2-hour course or a 2-hour presentation. The reason why is because if you would like a 2-hour presentation or be involved in a course that lasts 6 months that will explain every single moving part to the concepts that I am going to present today and to manifest all of the concepts that I am going to present today, you can go ahead and hit me up on Facebook or via Messenger. I'd like to take this moment and thank all of you who heard this introduction. Now I am going to unleash the beast. Anybody that's listening to this audio has heard of a secured party. I'm going to read the definition right now. The secured party is the lender, seller, or other entity that has rights to the collateral pledged against the loan in the event that a debtor defaults. I didn't make it up. It's on Google. Now I am going to explain to you what type of collaterals most secure party processes have. Okay. We've all seen the trust. We've all seen the common law copyright. We've all seen the security agreement. And we have all had the opportunity to see 21 pieces of silver, deeds, so on and so forth. But what does all that mean? Let's cut to the chase. Everybody wants to be safe. Only that the collaterals that you guys have in that trust or by yourself with the UCC and security agreement, okay, are not viable in any situation to get you out of any jam or being safe. So every time somebody walks into a courtroom and they say, hey, you know what? I have common law copyright. Don't use my name. Whoop-de-woo. $500,000 per infraction. Okay, you go nowhere. And we've all seen it. Everybody that walks into a courtroom and says, I am just a man. No shit. You're standing right there. Everybody that sits there and tries to use some sort of legal process that is not legally cognizable by bringing in claims that are not even part of the subject matter. You are out of your mind. They are immaterial. Okay? We can sit here, we can argue constitutionality, we can do all those things. Guess what? That's why I'm dictating through this audio and through this screen share as opposed to listening to those questions right now. Because I am going to single-handedly debunk all of those myths. And I am going to tell you, using one example and only one example. And then I'll touch on the rest of the examples, such as constitutional provisions and all that, at the end of this presentation, but lightly, because I told you this is not 2 hours. When you go into whatever situation that you are about to engage, you must, if you are going to be a secure party, have an asset that nobody can touch without your authorization. And there must be legal consequences that are cognizable in a courtroom. Okay? In a courtroom, in order for you to get some sort of preemption against whoever the assailing party is, so that they could stop doing whatever type of infraction, infringement, theft, or whatever, or at least have to, by a judicial order, obey whatever the hell you are speaking of. Okay, you're not going to get that by going to a judge with 21 pieces of silver. Nobody gives a fuck. And I'm pretty sure we all know somebody who's done it. So here we go. Common law copyright. Common law copyright, those are one of the assets. That is what we are going to address today. Common law copyright is the legal doctrine which grants copyright protection based on common law of various jurisdictions, rather than through protection of statutory law. Okay, and then it goes into that, it's a natural right, and then it gives you natural right has been addressed by the courts in the United Kingdom and the United States, and so on and so forth. Is the common law copyright a thing? Yes, it is a thing. If you want to read more of common law copyright, go to Wikipedia and type in common law copyright. That is my source. Common law copyright is a thing. The problem with that thing is the U.S. Supreme Court has ruled that individual state governments cannot be sued for copyright infringement. Fucking amazing. So when you ask them for $500,000, you have no recourse. 21 pieces of silver don't work. We told you that. Security agreement? How? What are you securing? All their bonds are with the courts. What are you securing? You think that you're going to force them or compel them to be forced into a contract? You cannot even secure their performance. Their performance is secured by the public trust. So all those secure party creditor packages are fucking defunct and accordingly debunked, but not in totality. The reason why I say not in totality is because I'm going to now show you why smooth operational law is superior to all other secure party processes. Our superiority comes from actually securing something. Copyright is a form of intellectual property. Nobody that knows anything. Excuse me. My nephew just walked in and tried to get my attention. And yes, you're hearing that on the audio. It is raw and uncut. The copyright is an intellectual property, which means that it is pretty much a working of your imagination. Okay, and I have it defined here. Copyright, the exclusive legal right given to an originator or an assignee to print, publish, perform, film, or record literary, artistic, or musical material, and to authorize others to do the same. So it's a form of security over artwork. Okay? Nobody in that courtroom is doing any type of artwork, unless it's a form of words of art, but that's just a manifestation of a form of intent. What I'm going to do now is I'm going to actually show you a statute. Title 28, U.S. Code 3002. The definitions, right? And we all know, and if you don't know, you will now know, the famous Title 28, United States Code, Section 3002, 15A. 15A can be seen as United States means A federal corporation. You highlight that. Let's read B. An agency, department, commission, board, or other entity of the United States. Or C. An instrumentality of the United States. So if it is a corporation, one of its agencies or entities, or an instrumentality like, I don't know, it's checks, it's money, it's security agreements, it's contracts, it's effects, it's treaties, then yes, in fact, the United States is a business. Common law copyright is wrong on those secure party packages because that is an artwork. You can't sue the government for the infringement of your artwork. Everything inside those courtrooms or everything that is being used by anybody who is in business with you to use those artworks or by some sort of state immunity or sovereign immunity can only give you protections of what it's willing to give you protections for. Now here goes all the guys, no. I can make up what I want. Yes, and it'll be considered an artwork. But guess what? The United States and all states do have a form of intellectual property, which is a form of property that is intellectual that they do give you protections for. The common law copyright's the wrong classification. The proper classification would be trademark. If you want an example of your name being used as intellectual property appropriately, think Michael Jordan. Think Tommy Hilfiger. What is a trademark? The trademark is a symbol, word, or words legally registered or established by use as representing a company or product. It's a mark. It's a mark that shows the sources of the goods and the origin of who made those goods. So what does that mean? It's your Batman symbol that you put on your performance. Your name, being a trademark, is protected to such a degree that you can actually sue government officials with impunity. Did I say immunity? No. The government loses immunity and you can sue them with impunity. Okay, well, I showed you the statutes for all the other ones, right? So why don't we go ahead and why don't we freaking show you the statute to that? Title 15, United States Code 1122 is the liability of United States and states and instrumentalities and officials thereof. A talks about a waiver of sovereign immunity by the United States, and it will mention that all agencies and instrumentalities thereof and all individuals, firms, corporations, other persons acting for the United States and with the authorization and consent of the United States shall not be immune from suit in federal or state court. In federal or state court by any, His headset just fell out of my ears. Okay. Shall not be immune from suit in federal or state court by any person, including any governmental or non-governmental entity for any violation under this chapter. But wait a minute, where the fuck does Title 15 United States Code 1122 fall under? It falls under the Lanham Act, which starts at Title 15, Section 1051 of the United States Code, and it continues on. Okay? And here's the cool thing. I kept saying common law copyright is a no-go. The error is take that word copyright out, and there is such a thing as a common law trademark, which is also known as an unregistered trademark. And I am going to show you the statutory provisions for that. But here's the deal, okay? The deal is that prior to the requisite of having to show what the actual infringement is, which is located in a later statute, after 1122, which is the one that I am currently reading, there is first the waiver of immunity. And then we need to inspect what they did so we can see that that waiver of immunity is actually allocated for. Okay, so let me pull up B first. And excuse me for shaking the screen so much, but B, waiver of sovereign immunity by the states. Any state instrumentality or a state or any officer or employee of a state or instrumentality of a state acting in his or her official capacity shall not be immune under the 11th Amendment of the Constitution of the United States or under any other doctrine of sovereign immunity from suit in federal court by any person, including any governmental or non-governmental entity, for any violation of this chapter. And the remedies are listed in C. Okay, and there are remedies that are both at law and in equity, and they are available to the same extent as remedies are available for such a violation in a suit against any person other than the United States. So that pretty much means that they will be robbed naked. The minute that they take your name and they use it on a document in their natural course of business, getting paid, whether it is by the state through taxation funding their job or their office. And the reason why they will be robbed naked is because fucking Congress said so. There's your statute. Now, do I have the Supreme Court cases in which they are not immune? Abso-fucking-lutely. And we're going to go through that real quick. Here are your statutes where you get to whoop their ass. At the bottom of C, and after it states that no state shall be immune, I'm trying to highlight it for you guys. Jesus, why can't I highlight this? There it is. Okay, let me bring it there, and let me bring it here. Okay? So here it goes. Instrumentality of a state or officer or employee of the state or instrumentality of a state acting in his or her official capacity. So they will be sued as a normal person, even though they were acting in their official capacity, which means they have no sovereign or state immunity or official or qualified or you name the immunity, judicial, absolute, nothing. They will have nothing. Now, such remedies include injunctive relief. 1116 is the title. Actual damages, profits, costs, and other attorney's fees under 1117. And 1117 actually states that if you have a registered trademark, you get $2 million per infraction or per situation. So you can make $2 million period, by statute, because there's a statutory provision that provides for the suit and waiver of immunity in a fucking federal court against state actors who go ahead and try to use your intellectual property, which is trademark. You're using the wrong intellectual property. I'm going to say it again. Not common law copyright. You can use a common law trademark. But a trademark gives you limited protections. Does that mean at the federal level? Yes, there are federal statutory provisions and state statutory provisions, the way that a common law copyright has state statutory provisions, even though you might not have a federal common law copyright. A federal copyright under Title 17. But both those law systems, although in effect, on the copyright end, the federal government has a preemption of the law used by the state, and they have a Supreme Court case that says that they can't be sued. With the trademark, you can use both laws, but you must balance those laws, and you can sue the judge. You can sue the bank. You can sue all other entities, all other people, as if they were naked. Wrong intellectual property for the common law copyright, registered or unregistered / common law trademark, correct. And then you have other remedies as provided under, and all the rest of those, all the way up to 1125. Now, 1125 is the one that I really want to get at. Give me a second. Lanham Act. Okay. The Lanham Act, 15 U.S.C. Section 1051, was enacted by Congress in 1946, and it allows for protections on federally registered marks, right? But here's the issue. Trademark violations encompass, okay, and I'm not reading it just yet, encompass unregistered trademarks. To establish a trademark infringement under the Lanham Act for either a registered mark under 15 U.S.C. Section 1114 or an unregistered mark under 15 U.S.C. 1125A, the plaintiff must demonstrate that the plaintiff has a valid and legally protectable mark. Now, hold on. Let's back that up. For a registered mark, it's under 15 U.S.C. Section 1114. An unregistered mark, it's under 1125. Well, holy fucking shit. The federal statute via Cornell University, okay? What is this? Legal Information Institute. Okay, yeah, but isn't this Cornell? Nah, it's not. What is this? This is propaganda. Hey, it is. law.cornell.edu. Hey, check this out. It just said the two statutes. Registered is 1114. Unregistered is 1125. Where did 1122 fall in? In between. You might want to read what's in between those two statutes, right? Because obviously 22 comes after 14 and before 25. You have the unregistered trademark option available. Now, what does that mean? The unregistered trademark option looks like such. Let's go back into fucking Wikipedia. An unregistered trademark or common law trademark is an enforceable mark created by a business or individual to signify or distinguish a product or service. It is legally different from a registered trademark granted by statute. Okay? Now, bottom line, although not required to receive trademark protection, an unregistered trademark owner can append the mark with the letters TM. The TM serves as a notice. Now, here's the deal. You can get someone to stop using the mark, but you must do business with your name. And it cannot be you using it as your identity. So you must make your trademark an intellectual property asset. You must use it with one of your entities and mark your goods and services with that entity's usage. And guess what? Maybe you might not go into that courtroom, but someone else who may just be in the position of a non-offending party can sue the living dog shit and get all of those dog shitters, them judges, them banks, whoever's hassling you, to shut the hell up because you have federal statutory powers. If you get a judgment for the use against the parties, right, who infringed, to stop using or stop infringing, you will therefore maybe nullify a case or two. You may be able to get a debt quieted. You may be able to have documents that were used in official capacities or commercial capacities because the United States and its member states are all corporate to shut their mouths, and maybe a felony might go away. You might get your guns rights back. Interesting little food for thought. Now, I challenge any motherfucker who goddamn says, hey, my process works. Okay, maybe it did. Maybe you might just do the whole litigation route and you have just become a lawyer without the degree. Nobody's saying there's not more than one way to skin a cat, and I'm always open to listening to very successful ways to skin that goddamn cat. But what I will tell you is that I just showed you on this presentation that there is another method to the madness, and that it is viable by statutory provisions. And I debunked anything that would be contrary or similar to this process. And what I mean by that is that contrary by effect would be the common law copyright. Similar, because it's an intellectual property, would be the common law copyright. None of those fucking two last ideas are viable. That's why they are debunked. This right here has been proven. Okay? Proven. With a Google search. So what I'd like everyone to do that's listening to this video is to take a moment and understand that this is only a portion of how to be a real secured party. This is only a presentation that I am putting out so that you can get an idea of how advanced and how proficient, okay, coming and joining my trustees empowerment management, okay, excuse me. God damn. I had a freaking, clear my throat. Okay. Empowerment pack. Okay. My course. How effective it will be. Okay. That's all I'm trying to tell you. It will have precise knowledge. It will have open sourced material that is widely available on the internet. I will show you what works, what doesn't work, just show you where it exists online, the cases that prove the method, and I will show you what you must construct yourself like. And by construction, I mean constructing your mind. Because think about it. If the asset that today I discussed is not a judgment, is not anything like that, we're not talking cars, and I am telling you how to keep yourself safe because most people want to be safe out of this commercial system, so you must have an asset that is commercial by nature, and that commercial asset that's commercial by nature is recognized by statutory provisions. Then you have a bargaining chip. And that bargaining chip needs to be your property, only that property that would secure you so that you can either lend or securitize or whatever would need to be something that is tradable in our system. And since we can't make money because that's a violation of, making fake money or Title 18, Section 513 and 514, which are counterfeit securities, then what is the only thing that we can collateralize? Well, if the money's fake and everything's a construct, then we must construct. And first we must start with our intellect. And it's intellectual property because we're going to learn how to make our property our intellect. And if it's our property, then who the fuck should be able to touch it? Nobody that we do not allow into our segment, zone, with permission, or any other authorized party member. And so intellectual property allows for you to own your intellect, provided by statute, cognizable to a court, claim, the claim can be endorsed, okay? And I'm going to leave you with one more thing. Okay? Because I've already left you with the fact that this could literally blow the corporate veil of any acting or state actor right off of his bench, right? It can blow that veil right off of that bench, and he will be a human being, right? Here's the deal. I kept saying that there is entities that we must make. Well, the reason why we must make an entity is because we don't want to be the offending party. The offending party is usually a defendant, okay? And the only people that can attack a claimant as a defendant would have to be somebody who actually has a cross-claim or so on and so forth. And we're not going to get into that because that's court procedure. But what I will say is this. Real party and interest, designation in general. An action must be prosecuted in the name of the real party and interest. The following may sue in their own names without joining the person for whose benefit the action is brought. And it tells you in E that it can be a trustee of an express trust. As long as you follow the instructions in the course, you will actually get the desired result that you are looking for. This is the end of my presentation. I hope that it wasn't so choppy. I hope that it was clear and concise. And I hope that you realize too that not only is it 100% effective, but for it to be 100%, for it to be 100% effective, you must learn the rest of the course so that you can control all other aspects and know how to conduct the procedure as the trustee of that trust with that intellectual property in it. And the fact that you have the intellectual property in it guarded by statute, and you have been taught with some OJT, some on-the-job training, how to protect your mark, your brand, and how to transfer it into society appropriately and prohibit and protect it with legal statutory provisions from anybody else who's using it, causing an infringement, no matter who it is. You must take the course to learn all of that. And those are a lot of moving parts. My name is Raymond from Smoothoperationoflaw. Y'all have an outstanding and yet curious evening or rest of your day. You can hit me up at Smoothoperationoflaw right on Facebook. Get in contact with me through Messenger, and we'll be okay. At the end of the day, I'm here. Starting classes soon. Bye-bye.